Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. In this video, we reach stage 7 in our series on 18 stages of a civil case in India. This stage is about one of the most critical phases in the civil trial: cross-examination of plaintiff's witnesses. This is the point where the opposite party tests the truth and credibility of the plaintiff's evidence filed through affidavit in the last stage. We will discuss legal procedure under CPC, rules of Bharatiya Saakshya Adhiniyam 2023 BSA, practical strategy, court etiquette, and illustrative examples. What is cross-examination? Cross-examination is the questioning of a witness by the opposing party after their examination in chief, affidavit, has been submitted. It is intended to test the truthfulness of the witness, expose contradictions or weaknesses, undermine the reliability of evidence. Only after cross-examination does the court accept the witness's statement as fully proved. Legal provisions. The process of cross-examination is primarily governed by Order 18 Rule 4(2) of the Civil Procedure Code 1908, which mandates that cross-examination of a witness must take place orally in court. Further, the Bharatiya Saakshya Adhiniyam 2023 under sections 138, 139, and 143 lays down the manner, scope, and limitations of cross-examination to test the credibility of the witness and the truth of their statements. Additionally, the Indian Oaths Act 1969 regulates the conduct of witnesses who are examined under oath, ensuring that their testimony is given with full responsibility and legal obligation toward truthfulness. Who conducts the cross-examination? Cross-examination of plaintiff's witnesses is conducted by the defendant's advocate or defendant himself, if appearing in person. The questions may cover contradictions with pleadings, inconsistencies with documents, bias, interest, or motive, unreliable or vague statements. Important rules under BSA 2023, sections 138 to 143. Witness can be cross-examined on any matter relevant to the case. Prior inconsistent statements. Digital electronic evidence and certificates. Use of leading questions is allowed in cross-examination, Sec 143. For digital documents, cross-examination may focus on source authenticity, metadata or device used, validity of Section 63(4) certificate. Digital evidence cross is now a key aspect post-2023 reforms. Example case: contract dispute. A plaintiff's witness claims in affidavit that a payment was made via UPI. During cross-examination, the defense counsel may ask, "Did you personally send the payment? Can you produce a screenshot from your own device? Was the UPI ID verified by the defendant?" If the witness fumbles or contradicts earlier statements, it affects the credibility of the plaintiff's case. Courtroom procedure and etiquette. Cross-examination is conducted in open court, on a date fixed for evidence. The judge records important questions and answers or allows an official stenographer to do so. The witness remains under oath and must answer truthfully. The advocate must maintain decorum, no insulting or irrelevant questions allowed. Rights of the witness during cross-examination. Witness may refuse to answer self-incriminating questions. Art. 23. Constitution. Questions not relevant to the suit. If a witness is harassed or badgered, the court can intervene. Summary. The primary purpose of cross-examination is to test the credibility and reliability of the plaintiff's witnesses. It is governed by Order 18 Rule 4(2) of the CPC along with sections 138 to 143 of the Bharatiya Saakshya Adhiniyam BSA, which lay down detailed rules for its conduct. Cross-examination is carried out by the defendant or their counsel after the affidavit of examination in chief has been filed. The scope of this process extends to all relevant facts, documents, digital evidence, and prior statements of the witness. Throughout the proceeding, the court supervises, records the testimony, and handles any misconduct to ensure fairness. A strategic cross-examination focuses on exposing inconsistencies, questioning motive, and verifying factual accuracy to weaken the opposing case. Advocate's practical strategy. Prepare in advance, study affidavit and documents. Ask short, direct, closed-ended questions. Begin with soft questions, build up to key contradictions. Focus on turning points that may affect the relief. Always stay within the scope of pleadings and framed issues. Common mistakes to avoid. Asking irrelevant or argumentative questions. Forgetting to question on electronic documents source. Failing to make the witness commit clearly to a point. Not recording important contradictions on the court record. If you found this information useful, please like, share, subscribe, and press the bell icon so you can receive more such important legal videos in time. I assure you that I will continue to provide accurate, lawful, and research-based legal information on various topics through this channel. Your support means a lot to me, so I humbly request you to stay connected with this channel. By joining this channel, you can also receive special legal information and membership benefits. Thank you very much for watching this video. See you soon in stage 8 of our civil case series. Jai Hind. Jai Bharat.